Well, hello everyone, and welcome to today's Walker Morris Tech Talk, where we'll be discussing the topic of disputes in technology contracts. We're talking about how to manage those disputes and hopefully some top tips on how to avoid them. My name is Luke Jackson. I'm a member of the Technology and Digital Group here at Walker Morris. By trade, I'm a commercial contracts lawyer, and my day-to-day role is very much involved in the drafting of these technology contracts. Thankfully, then, I'm joined by my colleague Louise Norbury Robinson, who sits in our commercial disputes team. Louise is also a core member of our technology and digital group, and Louise has plenty of experience advising our clients when things go wrong. So the format for the session will be question and answer. I've got quite a few of my own for you, Louise, but there is a chat function for you to raise your own viewers. This brings me on to a couple of housekeeping points. If you do have questions, the more the merrier. If I could ask you to raise them in the Q&A function rather than the chat, put them in the Q&A function just is easier for us to keep track of them if we know they're all going into one place. We'll try and deal with what we can, but anything we can't get to, we'll follow up with separately to answer your question. Obviously, it's a live recorded webinar, so if I can ask you all to keep your microphones on mute, and we're planning on sending a follow-up recording separately. So just to set the scene of the IT contracts that we're talking about here, really a lot of the content that I know we're going to touch on could apply quite broadly across the spectrum of software licenses, software as a service, big IT outsourcing, projects of implementation, integration, software development, and all the rest of that. So, and there'll be some things that I'm sure Louise will talk about that actually will just apply to contracting more generally. So hopefully lots of useful, practical stuff over the next 45 minutes to an hour. A lot of what we'll touch on will be kind of from the context of the customer perspective, buying IT, but I know that there will be one or two points that hopefully will be of use to any suppliers that are viewing as well. So, Louise, let's start, shall we? Can you just give us a flavour of what the main causes of disputes in IT contracts are in terms of how you see them?
Yep, sure thing. So thanks for that intro, Luke. We'll kick off. So main cause of IT disputes. So certainly pre-lockdown, I think perhaps not so much at the moment, but certainly pre-lockdown, I think it was very easy to forget how critical IT and technology is just generally to so many businesses. And yet, actually, many of us has a pretty limited understanding, I think, as to what goes on behind the scenes. Which obviously makes it a lot harder when we're contracting for IT services or deliverables. And I think that is, for me, one of the key causes of IT disputes, is a misunderstanding around either the functionality of the tech products that you're buying, or a misunderstanding about the requirements, if you're selling. I think customers, clients often buy in solutions that have either got too much or sometimes too little functionality, or just don't suit their needs, and there's a mismatch of understanding between the contracting parties, or just that the contract is simply, just not fit for purpose because of that misunderstanding. We looked in preparation for this webinar, we looked at a recent study that shows what some of the common TMT, which is tech, media and comms disputes are. Not surprisingly, IP disputes, which we won't touch on today, and just underlying structural disputes like the joint venture falling apart, that sort of thing. But in terms of actual the underlying IT, the biggest hit really was under licensing, as well as some IT systems and developmental issues as well. But under licensing was sort of the number one cause.
Dead right about the importance and sometimes the challenge of understanding the subject matter. Tech, not only is it very jargon heavy, but it's also like constantly changing and constantly advancing, doesn't sit still. So it can be a challenge to keep track of, and there's absolutely no problems then in just constantly checking with the client checking with like the IT stakeholders in the business to make sure you've got your head around what they understand the product to be buying or being sold. Now you touched on under licensing there. For anyone not familiar with that term, could you just give a quick explanation as to what it is and why it's so often an issue in these contracts?
Yeah, sure. So under licensing, sort of does what it says on the tin, really. It essentially describes the scenario where the software license that you've purchased, the customer's purchased, doesn't fully cover the scope of how that customer or client is actually going to use the software. So the simplest example will be where a business buys a license for, say, let's say 10 named users, but actually 20 users will be using it. That's a common sort of simple structure, but it's not just limited to the number of users. It can also be more complicated than that, which is where some of the disputes also arise. So how the software is actually used. So give an example, maybe you've got users within a group company. So the license might be granted to just a single named corporate entity, and it's granted on a non-sub-licensable basis. But then if that company is not aware of that and allows companies within the group to use it, that might be an under-licensing situation. One of the issues we find actually is that the license element of the tech contract is sometimes almost a tag on. So it sits outside the wider solution, almost as an afterthought sometimes, which is of course a dangerous territory. And the licensing models and metrics, certainly for some large solutions and large contracts that we see, it can be quite complicated. It's not just a situation of how many users have we got? We've got 100 people in the company, job done. It's much more complicated than that about how the systems will interconnect and will be using and essentially giving rise to a license requirement. So it's quite common for us to see businesses finding themselves under licensed on some of their key systems, and the big issue is that quite often it isn't found out or picked up on until an audit, which can be years, a couple of years down the line after you've been overusing, shall we say. And then therefore the financial shortfall can be very, very significant in those situations sometimes.
Just to give that some context, you say that the financial shortfall can be significant. Have you got any kind of recent case examples?
Well, yes, I have. So obviously the SAP and Diageo litigation, both parts, is a great, well, not so great for them, but it's certainly a shocking example of how under licensing fees can become very, very significant, a real problem for the business. Probably a lot of listeners will have heard of it. It's pretty big in the legal and the general press, actually. But for anyone who's lucky enough to escape it, I'll give just a brief snapshot. If anyone does want more detail about the case, just pick up with me afterwards, or there's a good note on Computer Weekly as well. But basically, SAP and Diageo was a case that looked in detail at the issue of under licensing, and specifically the issues between a direct use of software and perhaps an indirect use of software that might still give rise to a license. So SAP alleged that the users of third-party systems were indirectly using or accessing SAP's own software, and they said that the effect of that was that each and every user needed a specific and obviously, as it turns out, expensive category of license. So Diageo was hit with this. They were already a user of SAP's applications, so they already had a relationship with SAP. They already paid over £11 million annually in support fees and new licenses. So, a big setup. But Diageo put together or deployed 2 new third-party systems in about 2012. So you can see that it's, the thing was ongoing for a long time before it was picked up. So one of the systems was something that a lot of our clients and businesses are probably familiar with, where a customer is allowed to place an order online. But of course, to do that, the process underneath that means they have to be accessing an internal system and the data, which was held in an Oracle database, so not SAP, but it was associated with SAP's integration software. It gets a bit complicated, but to put it briefly, integration or intermediary software, called API software sometimes, is basically the intermediary, the middleman that allows the two systems to talk to each other. So if you go on a flight comparison website, when the weather starts to sort itself out and Boris says we can leave, you go onto flight comparison website, and the API or the intermediary is the bit of kit that allows you, the comparison website, to speak to all the airlines and work out where you can go and how much it's going to cost you. So that's sort of broadly how it works. And there was a second system as well that they deployed. And in essence, SAP said that both of those systems were using or accessing the SAP system indirectly, which gave rise to license fees. And unfortunately, for Diageo, the court did find in favour of SAP. They said it was pretty clear on the license wording that only named users were authorised to access and use the SAP sort of back office system, if you like. And because there were transmissions, albeit indirectly, with the underlying SAP software, that all of Diageo's customers essentially became users for that purpose. And of course, all of the customers were not named users in the license. So therefore, further fees were payable, and a similar analysis was performed on the second system as well. So it was pretty big stuff, and the finance was huge. I don't know, Luke, if you can take a guess at how much much SAP were claiming.
See, it was £11 million contract.
Yeah, so that was license and support as well over the year.
So £6 million.
54 million pounds was
Wow.
how much they were asking for at court. I mean, obviously, it'd been going on a number of years, so it's not quite as jaw-dropping as you might think, but it's still a pretty big number.
So I guess the under-license element there, it wasn't necessarily, it was less a case of they bought X number of licenses, but Y number of users were doing it. The issue wasn't human users; it was sort of computer. It was software that was interacting, and that was the under-licensing element.
Yeah, that's right, and I think that's what the headline really is. Just to avoid these sorts of issues, you need to understand why or how a license requirements has arisen, and then obviously you can understand how to deal with it in the contract. So in the SAP case specifically, the way that use, access, direct, indirect were defined was really important. Certainly the use and access definitions, which weren't properly in that contract. So just to understand and iron out what both parties think is covered and isn't covered, and understand exactly how the mechanism will work between all that integrating software. So that once you understand it, how and when a license requirement might come about, you can then work out how to deal with it in the contract. Top tips, I'd say, certainly for learning from that case, ensure the categories of named user are not exhaustive and not closed off, so that you've got some wiggle room. And yeah, I mean, if possible, just ensure that any use by a third party through the intermediary software, just make sure that doesn't attract a license fee, make sure that's covered off. But that might be easier said than done in the commercial world. But yeah, I think the headline is just to make sure you know how the software will all interact with it with the other software, so you understand, do a time map or whatever, so you can see how that would pan through.
Yeah, the key word that I picked up on there was understand, and it seems like the takeaway here is to make sure you've properly got your head around the precise scope of the license that's being granted, and also how the contract, if at all, deals with use beyond that license scope. So sometimes you might see like volume metrics in the agreement that kick in if usage goes up beyond the initial amount. So do a few hypothetical scenarios to test that they work as expected. Mm-hmm. And I guess this can be a problem because, as we touched on at the beginning, technology and people that use it, it can be a moving beast. So you might start out needing 1,000 licenses or license for particular narrow use, but the business could change. If the software license isn't growing or flexing with it, then you could find yourself in an under-licensing situation, even if at the beginning you were well within the confines of what you've bought. Yeah. Louise, the other big area of dispute that you touched on at the beginning was around the development and implementation of IT systems. So I guess really these are problems that occur right at the beginning of a project before things are properly up and running. So maybe there's problems integrating into the customer's IT environment and the project starts to run late or something like that. How can this be guarded against? In your experience, what are some clauses that if commercial contracts lawyers focused on that beginning, at the drafting of the contract, could help to avoid disputes in that area?
Yeah, sure. So you're absolutely right that, the answer is get the contract right, but that's very easy to say. And that's your job. Um, but yeah, I think it's surprising. A lot of this is common sense, but it's really surprising how often the basics are forgotten. So in the heat or the excitement of a negotiation at the outset, where everyone's getting on, everyone's optimistic, sometimes the basics are forgotten. So just allow yourself sufficient time and and that moment to pause and just check that, what's written down really does reflect what you need and what you want. And don't neglect the schedules. That's something that we see time and time again. That actually the schedules usually have the key information about what's being provided, what the expectations are, what the milestones are, and quite often they get the main parties get the main contract right, and then think, right, we'll sort out the schedules. We want to get going. We're excited to get going, especially in a development project or something, rather than a services project. We see that a lot, and then that just slips, and then all of a sudden you end up in a situation where you haven't got the services properly defined or whatever, and everyone's on the wrong page. So top tips will be what's the definition of services or whatever. When do the milestones kick in for payment? When's go live? When's completion? If it's a project, how exactly, going back to the licensing point, exactly how will it work? Make sure everyone understands and that you're getting what you were expecting. Who obviously is an obvious one, who's got to do what. I think that's the main thing, and clarity. So you said it before, Luke, but understand. So a good rule of thumb, I think, is that if what you've written down can't be understood by someone just picking it up cold that hasn't been involved in the negotiations, then you might need to revisit the wording. So that's quite a good sense check. So often the parties are so involved in the negotiations that they understand what they think the contract means, and it's possible that the person on the other side innocently often has a different interpretation. So that third party sense check would hopefully try and iron out any misunderstandings at the outset.
On that, Louise, as well, that's where I think, you talked about paying attention to the schedules, and there are some, I've seen some instances of IT projects where, the lawyers don't need to look at the schedules. You don't need to look at the schedules, negotiate the front end terms, because the schedules just contain the commercials, and the commercial or technical specialists will negotiate those. But a lawyer can add value to those, as you were saying, just by a fresh pair of eyes and a sense check that what it says in those schedules, even though it's not a legal content as such, and that it actually works and it operates. Because I suppose that's where, in the event of a dispute, that's where things can get a bit fractured from one side to
Yeah,
another. Sorry to jump in there, Louise.
no, and I think you've probably got more to offer on that side of things perhaps than I have, because obviously I see it when it's gone wrong. But one thing, I wonder what you think about contract variations, because obviously by the very nature an IT contract, it's usually a bit of a moving beast, isn't it? I think suppliers should probably explain and clients should appreciate the inherent nature really of an IT contract, or certainly a project, is that it probably will involve change. I don't know if you've got any top tips about how to deal with contract variations at the outset, and then
Yeah,
perhaps
I mean, my
as
thought
going.
on contract variation in the context of IT contracts, where a variation will often be in the context of a technical element of a solution that maybe needs to be thought through and agreed by both sides, by both parties to the contract. It's maybe not as simple as just this word in this schedule just needs changing to something else, or this line needs amending. It needs a little bit more of a new principle will be agreed. So that's why we often see these change control procedures set out. Talking about avoiding like going to get ahead of a dispute, if you can keep up to date with a maintained copy of the contract, you'll know about this, Louise, following variations to it. So once it's gone through the change control procedure, have a conformed copy, because as this contract snowballs and you get variation 1, variation 2, variation 3, if it's not kept up to date, it can be, I'm sure, a bit of a nightmare in putting this patchwork back together. But also it's really difficult just from putting disputes aside, just from a user perspective. If you need to look into the contract to say, what have we agreed on this? If it's contained in sort of 4 or 5 different places, it can be just a practical challenge. So how can you get around that? Well, as part of your as part of your change control procedure, make it the responsibility of a named party to keep that conformed copy. The last thing that happens after a variation's been agreed is party X updates the conformed copy of the contract and circulates it to all parties, so everyone knows where they stand, and everyone hopefully should have the same version, the most recent version of the contract.
Yeah, I've seen that actually in something we've dealt with recently, where and it seemed to work really well. That the change itself didn't become part of the contract and enforceable until that last step had taken place. They had like a shared electronic drive because they had loads of contracts with this particular supplier, but they had a shared electronic repository where until that had been signed off and placed in the repository for everyone to see, and it then generated some emails. It was quite high tech, but simply put, until that last stage. So in a normal contract, you'd execute it and then you send a copy, an executed or completed copy to the other parties, and it was that they said completed the change control procedure, and we had some interesting debate about whether that was enforceable. But it's just thinking ahead about how you make sure that everyone's on the same page as to change the scope, because otherwise you get what's known as scope creep, don't you? But it is inevitable certainly on bigger projects or complicated IT projects. But we do see that being exacerbated quite commonly if it's not at the outset, if the proposal's not properly explained, and then there's room then to scope creep, as we hear it called.
Just having that flex in the contract can be the difference in dispute or avoiding the dispute, I guess. For me, again, my takeaway from that is when you touched on taking the time to make sure that both sides are aligned on the what, the when, and the how, I think you put it. Because often there's time pressures around an IT project. A new platform or piece of software might need to be in place by a certain date for any number of reasons, but allowing that end date to have a knock-on effect on the quality of the contract by maybe rushing negotiations or not having a fully fleshed out agreement, to the extent if the customer and supplier are 100% on the same page as to what is being bought, when does it need to be in place by, and how will it be implemented, tested, and all of that, rushing to get that contract signed can be a bit of a false economy in terms of the overarching timescales. So, okay, let's move on then to, we've talked about some tips on avoiding disputes at the outset, but some things do go wrong. And what provisions do you like to see in a contract? What's helpful for the scenario where a dispute has arisen?
Yeah, so that's the thing. I think you need to think about these things in 2 ways, as we have done here. So, what do you need to get right in the contract so that a dispute doesn't arise? But then also, from the other angle, what do you need in a contract if a dispute does arise to sort of help you navigate that and get to the best outcome? The obvious one, and it is obvious, but it's a workable dispute resolution procedure in the contract itself. Now, I use the term workable quite specifically because often we do see dispute resolution clauses just as a bit of a boilerplate standard. So you get the template precedent clause from whichever lawyer's drafting it for you, or whatever your in-house one is. And very little thought sometimes goes into how that process might need to be tailored for this particular contract, or if it's a lawyer drafting it for that particular client, just to make sure that it's really workable and it's going to be suitable. Because actually, if those clauses are engaged properly, they might end up directing, or they should end up directing, how the dispute's to be resolved, gives the parties a focus. I won't go into too much detail here, but there is some sort of breaking news. It was out in the press this week. The UKJT, Lawtech UK's UK Jurisdiction Task Force. It's led by the Master of the Rolls, so it's quite exciting. If that's what keeps you excited, at least it does me. But it's they've published the final version of their long-awaited digital dispute resolution rules. So yet to see really how they work in practice, and we're looking forward to giving an article on that in a few weeks' time, but our insight on that about how it'll work. It remains to be seen what the uptake is, but there's been quite a lot of appetite. But the idea is that if, and it's a big if, but if the parties remember to incorporate or wish to incorporate those new rules into their contracts, then they'll become enforceable, and they'll hopefully speed up and reduce the cost of tech disputes, because when they can be expensive pieces of litigation. And within those rules, there's a real push towards arbitrators, but sort of arbitrators with specific technical experience, rather than pushing disputes towards the traditional court litigation. But like I say, those rules will only apply if you incorporate them into your contract. So that's sort of step one. But we'll be putting out an article on that in a few weeks, or maybe this week.
Good. Well, I'll certainly be keeping an eye out for that, Louise. Other than dispute resolution, then, are there any other clauses that you're always happy to see have been put in there from the outset, because it might give your client some extra protections or extra?
Yeah, certainly. So, I mean, the first thing to think about, I think, is over and above the dispute res clause will be the exclusions or limits of liability. Now, you do need to think about those carefully, and they do need to be carefully negotiated, just to ensure the parties are clear as to what's included and what's excluded, and what limits might apply, and make sure they're right for the parties. And that's both sides. Also, notice provisions. It's a boring one, but just make sure the notice provisions are workable. And what I mean by that is who you have to give notice to of a dispute or whatever. Ideally, for example, there'll be a fallback. So quite often we see notice have to be provided in writing to, Luke, for example. But what if Luke leaves or is unavailable or whatever? So a fallback position if that relevant person ceases to be there. So, for example, you might do a and copy to the company secretary, for example. The other one I'd say is an exit strategy. Now, this is this probably crosses over as to how to avoid a dispute and how to help manage one. I've put it in here for completeness, but I think it's important. So often we see that the exit strategy is left blank or not really dealt with. And I can't really stress how important the exit strategy is, to make sure that's workable. Because things do go wrong, and you want to, or even if just the contract runs its course, with no dispute as such, we see disputes arising if the exit strategy, if the contract's not renewed, there's no dispute as such. But then relations are not great if there was an expectation perhaps that the contract might be renewed, and there's exit strategy becomes very important, and from a business continuity perspective, it's vital. You might need to think about what incentive you provide, for example, to the outgoing supplier to ensure that they're incentivized to give you a good transition. And the other one I would say, it's often a belt and braces, but governing law and jurisdiction clauses. I lump those together on purpose, but it is a bit of a common mistake to think they're the same thing, and they're not. So the governing law, as it suggests, is the law that will actually apply to the contract, whereas the jurisdiction clause is the particular national court or courts that the parties agree should be hearing a dispute. And we do see, actually, if there's no clear jurisdiction, that can give rise to satellite litigation, so bolt-on litigation, before the dispute even gets off the ground. So I think just on one thing we often hear is people say, well, we're agreeing the terms, we've got a contract in place, so why do we care what the governing law is? They just say, well, that's not irrelevant because we've got our terms. And of course, as we know, the vast majority of contractual disputes arise because of the difference of opinion as to how to interpret those contractual terms. And that's where, the governing law is then important, because the interpretation of those terms may change depending on which country's laws govern those terms. So usually it's pretty obvious. Usually there's a straightforward answer to who to put down, but I think it's important just to make sure that you've got those clauses in so that it's one less thing to fight about, let's say.
Yeah, I guess it can be straightforward if it's two, English domiciled companies. But if it's an international transaction, then there might be more of a conversation around it. And it's, you do see kind of neutral venues as well, don't you, Louise?
You do, yeah.
Some really good tips there about the practical importance of some of the boilerplate clauses, if you like, a well-drafted dispute resolution clause, notice provisions, how they can be, it's not the most, from a drafting perspective, the most exciting clause to negotiate, but when it comes to it and the needed, they can be so important, right, as to how the arrangement actually functions. Completely agree about not overlooking the exit assistance post-termination clauses, because it's tempting, isn't it, at the start of a project to focus on what we're going to be doing, how we'll get started, obviously big discussion on the charges, and it can be a bit of an afterthought what's going to happen at the end, but having clear provisions around what will happen when the arrangement's finished can be so helpful, and particularly, we're talking about disputes here, if over the length of the contract, the relationship between the two parties has become a bit fractured and maybe isn't as good, as there's not as much goodwill as there was when the contract's actually being drafted and the deal was being done. So, I'll be looking to get things like commitments from both sides about returning materials or data, supporting each other in migrating away from the product that the supplier is providing. And, from a customer perspective, asking the supplier maybe to commit to a pre-agreed period, post-termination period, where they will continue to provide the platform or service. And
or sometimes a designated exit team as well is helpful. So the people that perhaps are a bit disgruntled that they're not going to be providing that service going forward or whatever, you almost take that out of it and just say, well, we'll have a designated exit team, because I think exiting an IT contract is almost a skill within itself. It's a different, whatever the services are that you're supplying, the chances are the migration of that service is almost a different skill set. So just a thought that you might want to think about putting an obligation in there.
Exactly. There's often commercially a temptation not to put these things in because it's potentially an extra cost. But that cost and there's a value in agreeing that cost and being clear what that cost is at the outset. But also it can just be worth it to avoid the pain and the difficulty in moving away. Particularly if this had been a project or a platform where there has been a substantial implementation or integration period. If it's required that, then it seems safe to assume that an equal amount of effort would be required to move away at the end. So one to think about, particularly if it's the subject matter involves substantial implementation, integration, or work at the beginning. So moving on again, Louise, we've talked about how to, and we'll do our best to prevent disputes, but they do happen, unfortunately. What are your practical tips for managing the particular IT disputes when they do arise?
You say unfortunately, but it's you're putting me out of a job this webinar. But yeah, no, you're right. It's not just about having the contractual mechanisms in place, but there are also practical tips. You can have the best contract in the world, but it's also about how you as a company or you as a supplier act if there is a dispute arising. And that, that could take up a webinar probably of its own, and do get in touch. But if you've got any specific questions, just a reminder, there's a couple of Q&A questions coming through actually, but if anyone's got any more, please fire them on. But yeah, I think my top tips would be act fast. That doesn't mean rushing off to court or sending nasty legal letters necessarily. It just means don't bury your head in the sand. Disputes can be damaging. They can be damaging for the reputation of the business, the relationship, derail projects, damage cash flow, obviously, and postpone what might be important go live dates. So I think, act fast at the outset. If you address a potential problem head on, then from a commercial perspective, it's much easier to put things right or adjust expectations when everyone's still committed to working together and getting things right, rather than perhaps waiting until niggles have started to creep in, relations have soured a bit. And on a more sort of a more positive note, perhaps, just simply putting up with issues because you want to carry on working together, actually in itself could in some situations result in a waiver of your rights in relation to that issue, or it's a legal term, but stop you potentially from making a later claim. So if there are those things creeping in, involve your lawyers or your in-house team at an early stage, really, just to make sure that everything is going, that you're protecting yourself and putting yourself in the best position if a dispute does arise. Second top tip I'd say is evidence. Keep that short and sweet, but it is what it suggests. Keep good records, even of minor issues, because minor issues can escalate. Especially if there's a cumulative breach provision. So, minor issues of themselves might not give you a right to terminate the contract, but cumulatively they might do. And quite often we see clients coming and saying, "Oh, it's been going on for ages," but when we're actually looking for hard evidence of those minor breaches or those issues, it's harder to evidence them. Post the event. So keep good records, evidence of milestones. Conversely, for the supplier as well, keep good records of your achieving the contract, of your evidence of the milestones being achieved, and those sorts of things.
Can I just chip in there, Louise? Because
Yeah,
you've got me thinking about service levels and like shoddy performance against service levels. And often one of the big gripes is that maybe a customer feels like the performance isn't quite up to scratch as to how they wanted it, but there isn't the service is still working or the product is still working, but it's just a bit, they from their perspective a bit not very good. Conversely, supply might think, we agreed it would do this and it's doing this. So maybe the service levels are being not quite met, but only just missed. And there wouldn't be maybe a cause for a material breach there, but maybe the customer would expect that if it was a particular service level, say availability of a service wasn't quite being hit month after month, it might expect a remedy in those circumstances. Comes back to being really clear in the commercial schedules as to what the principles are. Maybe the customer should be entitled to a service credit, or maybe if there's repeat poor performance, there might be a right to terminate. But how can the customer know about that? What information do they need to kind of demonstrate that? Well, it comes back to this evidence thing and reporting thing. So I suppose your tip here would be, if you feel like your service levels are being hit, as soon as you suspect that, start tracking that data. But one thing that might help there, and a point to maybe to think about when you're drafting the contract is, can you ask for an obligation from a supplier to proactively report on the service levels and to give you the information that you need as a customer to check that the service levels are being complied with? Sorry, Louise, I jumped in.
No, that's exactly it. So the obligation to report, because it can sometimes be hard to know if the service levels are being met or if there's anything going on. It's incumbent really, especially in IT contracts, more often than not, the deliverables or the service is quite often intangible. So we talked about this, that if you've ordered 10 red tables and 5 green ones turn up, it's wrong, or if they don't turn up at all. But quite often, especially in these big project contracts where maybe 2 or 3 milestones in, there's nothing to see, there's nothing to see for it, but to show for it, but it doesn't mean that that work hasn't been carried out. So evidencing from a supplier's perspective as well, evidencing the work that's being done, not just from a service delivery perspective, but a development as well. I think just to finish answering your question, Luke, other tips that, what can you do when things go wrong? Just the one thing we do sometimes see, and I would avoid against it unless you've had legal advice on it, is beware threatening to terminate. When relationships are starting to sour and think, oh, well, fine, I'll just go somewhere else. And by all means, reserve your rights to terminate, but just be quite careful and cautious of threatening to terminate, unless you've got proper advice, because it can sometimes lead to an unintended termination, which again we can advise on, but it can be. And that's the sort of worst, and at best it can just be disruptive and give the other party a claim in damages. So and the final point I would say is just check the contract. If things are not quite starting to go wrong, not quite starting to add up, as you touched on, Luke, you think, well, are the service levels being missed here? Check the contract, get someone to check it through for you, or check it within your teams. Is there a dispute resolution procedure that you should be following at the first sniff of a dispute? Is there a notice you should be giving? Do claims have to be notified in a specific way? That sort of thing. So I guess in summary, involve your in-house legal team or lawyers at that early stage just to protect yourself.
I've got one eye on the time, and I'm keen to get to some of the Q&A questions that we've got, but just to touch on one of the points that you just alluded to there, Louise. You talked about that inadvertent or unintended termination. So is there a risk that maybe parties could maybe in discussions effectively terminate, or there's an argument that they terminated a contract without perhaps meaning to? Could you just give us like 30 seconds on anything you've seen in that area?
Yeah, so the issue is that if you threaten to terminate, you could be, anticipatory breach of contract, and if the other party, that's the legal term, and if the other party accepts that as a repudiatory breach of contract, to give it the proper term, then they are entitled to treat that contract as an end, as a result of your perhaps inadvertent threat or breach, and then claim damages. And if that, if it's a service contract that was due to run for say 5 years and you're only a year in, then the damages might be, the service fees that they would have had for the next 4 years, for example. I mean, that's perhaps an extreme example, but I mean, don't get me wrong, it's not that you can't say anything. You'd have to be pretty clear that you intended to terminate. But we do see it. We do see emails saying, well, if you don't sort this out in 5 days, I'm off. Type language, especially especially when when it's really affecting the poor performance, affecting your business.
So I guess the message is involve the lawyers before you start using the T word.
Perhaps, yes.
Okay. Right. Let's move on to some of the Q&A questions then. The first one that I'm going to ask: what's the number one thing that makes you groan when you look at an IT contract?
I liked that question. I'll keep that dead simple. It's blank schedules. Blank exit schedules, just blank schedules. We'll talk about the detail of the services later, and then obviously as lawyers it becomes very hard for us to advise definitively on whether there's been a breach if there's no clear agreed definition as to what was expected at the outset.
It goes back to the point, doesn't it, even if you feel like you might be able to if it requires a commercial specialist to negotiate the schedules, at least you can add value as a lawyer by just doing a sense check and challenging why is this page blank. The next, let's move on, because I like to try and get through as many of these as we can. If there is a breach, can you stop paying for, or if you're a supplier, when can you stop performing?
So we get this ties in, I suppose, to the last point we were making about can you just down tools or threaten to walk away? And this is a slightly different point. I think what they're asking is can you cease, suspend services, or can you stop paying? And the answer, firstly, obviously, where law of England and Wales. I think the position is slightly different in Scotland. I had an example recently where the Scottish law provision was a bit more helpful. But broadly speaking, under English law, you're looking at the contract itself. You need an express provision in the contract that says if milestone X is missed, I can cease paying, or if service levels are missed 3 times, I can cease paying until it's sorted or whatever. And conversely, you might want to put in an express provision that if X, Y, and Z happens, we are entitled to suspend services or suspend. That might be more appropriate in perhaps a project, along a developmental project, for example, where you say, until you've paid or until X, Y, and Z have happened, we can down tools. Because if there isn't an express right, that there is no sort of implied or common law right in English law for a party just to suspend performance. So generally speaking, I say that very caveated in a very caveated way, because it does turn on each one will turn on its facts, but generally speaking, there isn't a common law right, so it comes down to what's in the contract.
The answer is involve your lawyers again. Okay, so yeah, there's a big move, someone's asked, towards cloud solutions, software as a service solution, I suppose. Often these have a complex virtual infrastructure. Do you have any tips from a contract perspective to avoid disputes arising particularly in respect of data integrity?
Yeah, sorry, I was just digesting that. Yeah, so I mean, we are seeing a lot of cloud-based solutions. They've been around for a long time, but you're right, there's still real growth in this area. I personally think as people become a bit more comfortable with the concept of essentially sending your data off into the ether, or into space, as I've heard it referred to by one client. And I think that comes down to the number one tip, I would say, especially with data integrity in mind, is to know where your data is stored. Where is the data center? It might not be the UK, it might not be England if that's where you're contracting. So in order to understand and accurately assess the risks of that, of managing that data and maintaining the integrity of it and keeping it safe, basically. In order to understand that, you need to understand the laws of the place in which it is stored. You might take some comfort if it's England or perhaps the US or certain other European states, but there might be some places that you're not familiar with the requirements, or the it's a bit less stringent, for example. So that's what I'd say there.
I think the big risk there is this thing of where is the data held. The beauty of a cloud hosted or as a service product is that the product itself isn't being stored, the data isn't being stored on your systems, it's being provided over the internet, but you don't know where the other side of the internet is. Where it could have come from anywhere in the world, I suppose. That's the thing about where these data centers are. Where is the data actually going when it goes out of your machine and off over the internet somewhere? And if it's in a jurisdiction where there are not equivalent data protection laws, then it can be a real challenge. Now, I know the last WM Tech Talk was on this exact subject, so we'll hopefully be able to provide a link to that. Really good hour just talking about this, really exploring this topic. So we'll try and provide a link to that in the follow-up materials. We've got another question on cloud. Here it is. As a business who enters into various cloud-based contracts, we've found it quite hard to show poor performance amounts to material breach, which means, therefore, that it's hard to get out of contracts, especially where material breach is not defined. Do you have any tips for that situation?
Yeah, I think the question probably preempts the answer a bit, but you're absolutely on the right lines there. So as well as defining certain events that the parties might class as material breach, long outages, failure to hit the key milestones, things like that. We touched on it before, but why not think about cumulative provisions? So for less serious breaches, but which, when they're happening all the time, taken together, do amount to material breach. We see that quite often, and I think that's really helpful for two reasons. So especially in cloud-based solutions, because of course there's that little bit less visibility and sometimes that little bit less understanding. But I think if you have a cumulative breach clause, even if it's not accepted, so if you say, well, if that's not a breach in itself, but if you do it 3 times within a month, it will be a material breach and therefore give rise to a termination right. Even if it's not accepted, it's an incentive for the supplier to rectify persistent breach if it is accepted. But it also just gives everyone a feel for tolerance levels as well. So what might just seem as a non-issue to the supplier might be really important for the customer, and vice versa. If there's a vice versa, the customer might say, well, that's not acceptable to me, and the supplier might say, well, look, that's a very real possibility or likelihood at that minor level because of X, Y, and Z. So it just opens up a conversation at the outset, and then the parties can negotiate a position that works for everybody and that everyone's on the same page at the outset.
There is a challenge with cloud hosted products in that often the terms will be more take it or leave it, because the solution is more fixed, like a mass market product. So there's less scope for customer to get negotiations and improvements from the standard terms, and then which leaves the kind of standard SLA, which may not necessarily be to the customer's liking. So a lot of cloud hosted products can turn on, does the customer, do the supplier, do they trust each other, and do they want to work with each other? Because the terms, there's often not as much wiggle room in the terms from what I've experienced. I'm conscious of the time, Louise, so we're going to have to park some of the questions that are coming in. Last question from me. I would like to know your top tip or number one takeaway that you can provide viewers. If nothing else from this session, what's your number one tip?
It was all brilliant. What do you mean? No, I think the number one thing for me is just don't do the ostrich approach. Don't bury your head in the sand. If things aren't going right, as we said before, evidence it from an early stage. Act fast. Doesn't mean act dramatically, but act immediately. To put it on your radar at least. Start evidencing issues. It's never too early to involve your lawyers, and I know that's an obvious thing from a lawyer to say, but a small outlay just to keep things on track can avoid a bigger issue down the line. So that's my takeaway from it. Just act promptly. What about you, Luke? You've listened to a lot. What's your number one takeaway, do you think?
Yeah, I think for me, just reflecting on everything I've talked about, it's the importance of really having, as a lawyer, wrapping your head around what the deal is, what the subject matter of the contract is, understanding how it's supposed to work, how it fits in with your clients, if it's a customer, how it fits in with their wider IT environment, what they want it to do, and if you're acting for a supplier, how they want to make it available to the marketplace. Understanding that, and then understanding the mechanisms in the contract. So we've talked about licensing, test like the licensing metrics, if they're in there, do they work? If volume bands increase, what happens to the pricing? Does it go where you want it to go? Similarly with service levels, how do those calculations work? If we've got a service credit calculation, does that work? So yeah, ask lots of questions, run lots of hypothetical scenarios. If this happens, what would you expect to happen next? The contract doesn't say that, so let's have a discussion, or let's maybe try and change something. So, but for me, what it all comes down to is understanding what the subject matter is and where each party's coming from in terms of the deal.
Yeah.
So a couple of minutes left then, and just before we close, as we touched on earlier, we are going to follow up with an email to viewers where you can access a recording of the webinar. We've also produced a checklist, a document with some of our top tips, things to look for when you find yourself in the situations of drafting one of these contracts and potentially thinking about things maybe not going so well in one of these contracts, what to do then. This is part of the Walker Boys Tech Talk series. As we've said, we do have some more coming up. They're due to be announced imminently, I'm told, so keep an eye out for those as well on social media. If we can put details in the follow-up email, we will. All that remains is for me to say on behalf of myself and Louise, thanks very much for joining us and have a good rest of the day.
Yeah, absolutely. We were just to say as well, we will get back to any of those Q&As that we didn't get
Yes,
to, but if
we
there
will,
is anything
absolutely.
else, just ping us an email. I don't mind that at all, and sure Luke's the same.
Yeah, we'll follow up with those contact details. Thanks, everyone.
Cheers.